Well, good afternoon, Las Vegas. Have you been traveling far without a home? I have. My home was stolen from me by Judge Alan Earl, a district court judge here in Nevada, and now Judge William Gephardt is continuing the theft by awarding legal fees to judges that lost the case. He's awarding legal fees to non-prevailing parties. That is against the American rule. It's against every kind of rule I've ever heard of in the jurisprudence here in the United States. The only time a judge can ever award legal fees to a non-prevailing party is that if that party had some kind of a vexatious or a case with no merit filed against them, maybe as a cross complaint or something that was just specious and had no contention at all that had any merit to it, then a judge it makes him kind of like a prevailing party on that particular issue. So a judge can award uh, fees in that case because of the vexatious actions of, let's say, the plaintiff put in some kind of a cross complaint that had no merit. So if you followed all that, fine. If not, well, whatever. But my point is that a judge cannot award fees to anyone that is not a prevailing party. That's period. That's the Constitution of the United States. It's been held up in courts all across this land on a daily basis. Every single day, there's this issue may come up across this nation. And here we have a district court judge, Judge William Gephardt, who, as a justice judge, rated a 62 ranking report card, if you will, from the lawyers that rank judges, whether they should be reelected or not. They come out with a report card. It's published in the Review Journal, and it gives the lawyer ranking. And Judge Gephardt ranked a 62. Now, I think, just my opinion, that any judge ranking lower than 70 should not even be considered for reelection. Well, what did they do in this case? Judge Gephardt was a justice court judge, and he ran for district court and got elected, and he had a 62% rating, if you will, in the justice court. This is not a judge that should go on. He doesn't know the law. In my particular case that he's trying to rule on now or make some sort of a whatever, he totally is lacking subject matter jurisdiction. And he said the other day in court in front of witnesses that he didn't care about subject matter jurisdiction. My attorney raised the issue that the judge did not have subject matter jurisdiction, and Gephardt responded that he didn't care about that. So that's the most important thing for any court to have before they can make any rulings in a case whatsoever. They have to have subject matter jurisdiction, and Gephardt doesn't have it. And when you raise an issue of subject matter jurisdiction, the burden is then on the court to prove that they have subject matter jurisdiction before they can proceed in the case and make any orders or rulings or anything else. They're wasting their time if they don't have subject matter jurisdiction. But the games they play in these courts, they think everybody's a fool, and for the most part, they're correct. Most people don't know the legal situation. But I've been blessed with this case now going on 7 years, and I spend every waking moment doing research and so forth and looking at precedences and prior cases and getting a handle on what the law really is. Let me put out there to you listeners what the law is in this particular case, or any case for that matter. If you go before a court, let's say in a civil matter, not criminal, that's kind of different in a lot of respects, but a civil matter where you have a complaint against somebody that damaged you. So on my particular case, I made a contention that my sister was stealing money that rightfully belonged to me. And to prove that, I need access to the bank records, or at least a bank statement that'll show me what's going on with the money that she transferred from New Hampshire, from our estate, transferred money into her personal bank account here in Nevada. That's called commingling. Okay, that's a breach of duty. when you commingle money that you are been entrusted with to protect for somebody else like me, to commingle that money with your own money is a violation of your breach of duty. And that in and of itself is actionable. So I had to file a suit because my sister was actually giving me fraudulent documents, I guess thinking that was going to shut me up, like I just was born yesterday. These bank statements that she made up were generated on a home computer. They're totally fraudulent. They don't look anything like any bank statement I ever got. This was a very, very, very poor attempt, one of the worst I've ever seen. But that's the qualifications that my sister has between her ears. She has zero. So she thought that she was going to fake me out, a businessman my whole life, college educated. I ran businesses. I ran big, gigantic hotels. I went into business on my own in the oil business. I was in court often over land issues and lease issues and this and that. So I have a lot of experience. I have experience with transferring money with banks, with all that, because you're talking about a lot of money in the old business. So I knew what bank statements looked like. And what my sister was passing off as bank statements is a joke. But anyways, I needed access to those records because when you're dealing in a court of law, all they go by is proof. Supposedly, that's what they're supposed to go by. So if you don't go to them with proof, they're not even going to pay any attention to you. So I needed access to those records. Well, for a year and a half, this Judge Earl, who had no clue why he had gotten this case, he had no clue what the case was about. This was a judge that was assigned cases for construction defects. Usually when they build these big hotels, let's say $1 billion hotel, at the end of the day, after the building's completed, there's $100 million that's owed to the contractor. That's called a holdback. The normal one is like 10%. So the contractor's looking for his money. The owner now comes up and complains about the window not being thick enough, the carpet wasn't the right color, this and that, all these specs were involved. So they're going to fight over this $100 million. So here come all the lawyers, the contractor lawyers, the lawyers on the owner's side of the table. They all get in front of this Judge Earl and they all yell about and scream about the size of this, the strength of that, the specs over here, the specs over there. Well, the bottom line of a complicated mess like that is that usually all the lawyers get paid on both sides because they both have issues that they have merit. They have to figure out who's right, who's wrong, but they all have merit. Anyways, this Judge Earl was used to all the lawyers being paid. So he had no clue why he got this case, and it was a simple case. And the reason he got assigned it, I think, is because he had very little to do because the construction boom in this town came to a grinding halt in '09, and he didn't have any buildings that had gone up since about '05 or '06. So there were no buildings that had just been completed that they were going to fight about. So he had nothing to do. So they assigned him this simple case over an issue of bank statements. The plaintiff wants bank statements. That's all. Just give me the bank statements. Well, it took a year and a half of my sister hiding the statements, refusing to give them up. She got a lawyer, some ambulance chaser named Howard Reutemann, was the biggest piece of crap I ever saw as far as a lawyer goes. And I've met a lot of lawyers. Some are good, some are bad. Most of them all have an agenda, but that being said, this particular lawyer was a buffoon. He would submit motions for this and that were totally in bizarro world. And even my lawyer would respond to some of these motions, calling the defendant's motions moronic. Now, it's very unusual to have a lawyer call another lawyer a moron in a context of being in a court case, but that's what my lawyer was calling this guy's motions were moronic. Well, there you go. So, anyways, Judge Earl did not know trust law. The last day of the trial and closing arguments, he put on the record that he didn't know anything about trust. As a lawyer, he didn't handle any trust work, and as a judge, he never handled any trust work. So in his whole legal career, spanning some 20 or 30 years, he never handled a trust case. And this was a guy that made this my simple case over bank records into a trust case, and he didn't know anything about it. What kind of judge is this? It's called not competent. That's not a competent court. But anyways, he had no clue what the trust issues were. There were no issues. He couldn't even hear a trust case because the trust case that we're talking about held property in New Hampshire. This was a New Hampshire trust created under New Hampshire law and governed by New Hampshire law. And that's it. The court here in Nevada has no jurisdiction over that trust. None. My mother died in Nevada, but she was only here because it was the winter when she died, and she would spend the winters here since she had a stroke for like 4 years. She would spend the winter here in Nevada because she couldn't take the winters in New Hampshire anymore for health reasons. She was a resident of New Hampshire. Her property was in New Hampshire. All her assets were in New Hampshire for the most part, except the bank account out here where she keeps some money in case she needed to go to the store and get money from an ATM or something. So her life was in New Hampshire. Now, you can't say just because a lady died here in Nevada, people die every day all over the country. They don't necessarily be home to die. You can die anywhere. So that it was irrelevant. But this court never could have, never would have jurisdiction over a New Hampshire trust. Now, all states create their own trust law. Nevada supposedly puts themselves as being one of the best states in the union to create a trust in. They have the most advantageous laws to protect the creditors. I mean, the settlers, the people creating the trust, creators I meant, and the beneficiaries against judgment creditors or what have you. So there's supposed to be great protection here in Nevada. Well, that's turned into a big laugh because if you were ever to create a trust in a particular state, the first thing you need to check out is what is the reputation of the judiciary? Is it an active judiciary? Do we have judges that are making laws from the bench? What kind of judiciary is it? Well, in Nevada, it doesn't take too long and you find out that the Nevada judiciary is ranked F. That's the worst ranking you can get until they make a G or an H. Or sometime, I guess, would progress on to a Z. But Nevada's heading in that direction because they have one of the worst judiciaries in the country. They're ranked 46th out of 50. I guess there's three states somewhere that have a worse record in judiciary than Nevada. I don't know where they are. Maybe I have to do some research and find out what those other states are, and what their history is, because it's hard for me to believe that anybody is worse than Nevada. It just would blow my mind because I don't think you can be worse. You can be as worse, but you can't be worse. And this is what we are faced with here in Nevada when you have a judiciary that totally does not rule by law. All I ever asked for from this Judge Earl was that he ruled by the law. What the judge told my lawyer in me answering that was that I was making a big mistake. So I asked a district court judge here in Nevada to rule by law. And the judge's response was, I'm making a big mistake. So there you go. If you're a Nevada citizen or you're entertaining filing a case here in Nevada before the judiciary here, you better think twice. Worse than that, you better not do it at all because you might as well just be giving the court everything you have because they're going to steal it until you're so flat broke you can't go on and make any contentions that the court didn't do this right or that right. You're out of business because they broke you. That's what the Nevada judiciary is. It's a criminal enterprise. It qualifies as a RICO court that needs to face RICO charges. Back in 1970, the Congress of this country developed a law passed by Congress called the Racketeering Influence Corruption Organization Act. And what that was actually after at the time was the enforcement agencies needed extra clout to be able to go after the mafia. And the mafia had grown since the brilliant government illegalized booze back in the 1920s, was really feathered the caps of all the illegal enterprises like Al Capone and so forth, and created a monster. And this monster from the 1920s and 30s had grown into a corrupt organization called the La Cosa Nostra, the mafia, whatever you want to call it. It had gotten to the point where the government needed help to be able to combat them somehow. So Congress, in response to that, passed this RICO Act, they call it, Racketeering Influence Corruption Organization. Well, you know what? The courts have progressed to such a low level in this country now, with all their F grades and everything around, that RICO laws need to apply to the courts, and they do, and they have. There are some judges sitting in jail right now that have been found guilty of RICO violations, having done what they did. There's been a couple cases out of Texas, I know, but they're out there. You can look them up on the internet. So courts are not immune from doing illegal acts. Quite to the contrary, they pass immunity laws to protect judges from rulings that they make at the bench that maybe in a year or two or whatever it comes down, maybe they made an invalid ruling or maybe they misapplied the law or whatever, but the judge was doing it in his capacity as a judge in a case that was before him. So they give the judge immunity because you can't have judges that have this burden placed on them that every time they make a ruling they have to be right, or someone's going to come after them with some sort of an action and make them personally liable. I agree with that theory, but the theory goes haywire when these judges, because of the immunity that they think they have, they break the law intentionally to get their agenda done. And in the particular case of my situation, the judge's agenda was to pay all the lawyers in the front of him all over the place, because that's what this judge was used to doing. All the lawyers get paid. And that's what he was trying to do. He was trying to pay this losing defense attorney who had the audacity to submit a bill for his services of $600,000. Did he get my sister mixed up with the OJ case or something? What the hell did my sister do that represented a $600,000 legal cost? She stole $26,753 from me, and that came down to the judgment finally where I was awarded that money that she had to return to the money trust. So she broke the law, she misappropriated money, that's what she did. And her ambulance chasing lawyer thought he could now retire by submitting a bill for $600,000. Now, this was a case over money that she transferred here from New Hampshire. She was stealing the money. She deposited in her own bank, and she was using it like her piggy bank. And anytime her checking account got in a negative balance, she just transferred money right into her account from this money, trust money. And that's the way she was doing it. And she did it until we finally stopped her. And and then at the end of the day, when the judge makes his ruling, he removes her as trustee. This is all I ever wanted, really, was to prove that she was doing this and to get her removed. And the judge did that. And then the judge goes completely off the rails of legality because he then decides that now the biggest issue before it left to be done is to award all the legal fees and from what source they can be paid. Now, what is this about? Hold on here, Judge, hold on. She committed a breach of duty and she was stealing money from a trust. And New Hampshire trust law dictates that if a breach occurs when you're trustee and you've been misappropriating money, that you have to restore the trust to the original condition before the breach occurred. So she's responsible for 100% of all the expenses and fees and whatever is attributed to her breach of duty, her theft, if you will. She's responsible for all those. So what is this judge talking about? Awarding fees from the corpus of a trust to pay her lawyer. Her lawyer doesn't get paid. And this judge, not knowing the law, not having a clue what he was doing, decides to make it in his ruling that, and this was a money trust, okay? This is a separate trust. A money trust, different owners, just me and my sister owned this trust. She was stealing this money from me, and that was the money trust. Well, she lost that case. She even had to pay back the money that she stole. So this judge in his, I don't know what you want, I don't know what to call this judge. But anyways, he decides that, well, the only place where there's any money is in New Hampshire in the form of that house. Well, but that house is held in a different trust with different owners. So how you can't award money, you can't do what he's doing anyways. At any stretch of the imagination, a judge in Nevada cannot dictate the sale of a home in New Hampshire to pay lawyers in Nevada. That just cannot be done, period. Now, there's other things that he tried to do that he couldn't do either. But when you start with the biggest thing, which is subject matter jurisdiction, he doesn't have it. And that makes every single order this judge ever made after that point is void. His entire ruling, his entire everything is void. And the other thing about his ruling, where he did remove my sister, the first paragraph of that decision states that all parties agreed that this court had subject matter jurisdiction. Well, that's a lie. And not only is it a lie, it can't even be done because nobody can agree to subject matter jurisdiction. A court either has it or they don't have it. And in this particular case, because property was involved, it boils down to the following, and only the following. Where is the property? Is it within the borders of Nevada or not? That's the question, and that is the only question. Well, the property in this particular case was in New Hampshire. So it wasn't in the borders of Nevada. So this judge is completely without jurisdiction to do what he was attempting to do. So his entire decision in regards to how is he going to pay the lawyers is void. Well, Judge Earl, being the illegal judge that he is, not competent on this particular case, and don't get me wrong, he may be one of the most competent judges around to hear a construction defect case. I don't know. I don't have any experience in front of him in a case like that. The case that I had in front of him was a very simple case, and he could not handle that. So I don't know how. They built a building down there on 6th Avenue here. On the side of the building, it has complicated litigation facility. Well, I guess he's used to complicating everything because I don't know how you could present a case to a court of law that's simpler than what I presented. I wanted access to bank records. As a primary beneficiary in a trust, I have every right to access to those records. My sister was submitting fraudulent documents to me that she made up on a home computer. So this is fraud. Good God, Judge, just give me those bank records. Well, she kept, not producing them. Well, when you're in a court case, you have discovery, right? And there's deadlines in that discovery. Well, the deadline would come and go. She hasn't submitted the document. So what did the judge do? He just gave a new deadline, and then another deadline, and then another deadline. He extended the deadline for discovery 4 times. All he had to do was compel my sister to produce the records. Let's say within 2 weeks, to be nice. I could submit records if you asked me for them, a bank statement. I could submit to you within less than 1 minute if I had access to a computer. Well, give her 2 weeks. The judge didn't do that. The judge, for whatever reason, being incompetent, I would guess, did not have a clue what he was doing. As a result, I paid the price because my lawyer is setting motion after motion after motion, costing me money and billing hours and money. And of course, the judge, he doesn't really care about what the lawyers are costing him because the lawyers must make money because otherwise, how are they going to turn around and contribute to the judge's campaign? You know that in this particular state here in Nevada, judges are elected. That means they have to raise campaign contributions. So what's a judge going to do? He has to get money from someplace. So the way they do that is they make sure that the lawyers make plenty of money. So as far as a case dragging on, going on forever, that's all part of the system here. A bailiff in the court once told me, how do these things go? He told me, well, they usually end when everybody runs out of money, not before, because the system works on money and that's the way it is. And that's the truth, you see? So that's a bailiff that works in a court. All he does is observe day in and day out what's going on, and that's his opinion. And I'm sure it's a very accurate opinion. It's right on. And that certainly proved true in my case. But anyways, this judge made a ruling that's completely invalid, completely not pertinent, and totally without jurisdiction. And I said this from day one, you don't have jurisdiction. We raised that issue so many times in court in front of this judge that he got so tired of hearing about it that on the record one day that appears in the minutes of the court proceedings that he made a statement that he was disinclined to hear any more discourse over jurisdiction, that he had it and that's all there was to it, and that was it. So he didn't want to hear anything more about it. Well, that's fine for you to say that, Judge, but it doesn't make it go away. You do not have subject matter jurisdiction, period. Why do I say that? Doesn't take a genius to figure it out. Where is the property that you're talking about? It's in New Hampshire. End of case. You don't have jurisdiction. Well, this judge proceeded to let this trial go on and on and on over a period of 6 months with time off because the judge was sick. At one point, the defense attorney couldn't go on because he was drunk. And, it was quite a fiasco. This court had spiraled totally out of control. The judge lost all control of this court. And all that was happening with these lawyers were just eating up the clock, creating billing hours. And that someday they thought they were going to get paid because this judge was going to rule to go outside of the state of New Hampshire and somehow sell property and this and that and get all these lawyers paid. Because that's what happens in Nevada, a completely corrupt system. So anyways, that's what happened. Long story short, the judge makes an order that the losing defense attorney, who had submitted the $600,000 bill for legal fees, arranged to sell the property in New Hampshire through a broker back there, I guess, and then get the money, give it to the judge here in Nevada, and then he would immediately make a ruling on legal fees and distribute the money to the lawyers on that basis. Well, that's all fine and dandy, Judge, but you can't do that because you don't have subject matter jurisdiction. Anyways, he was going to do it. So the minute I heard this ruling in April 29th when he came out with it, I think it was filed May 22nd. As soon as I found out about this ruling, I said, that's illegal. You can't do that. It's unconstitutional. Well, so my lawyer at my request filed a motion for a clarification where this judge had put in his ruling that my sister was not competent to be a trustee of a trust that was so complex. Well, there was nothing complex about our trust at all. The property that was involved paid 11 bills a year, which consisted of a light bill, a phone bill, a cable bill, and paid taxes twice a year, and insurance. That's all the bills that was associated with that home. It was paid for. There were no loans. It was bought for cash back in the 60s and been in the Feeley family going on 50 years. And it was a summer home that we enjoyed in the summer on Lake Winnipesaukee, one of the most beautiful lakes in the world. So it was a great piece of property. And over the 50 years that we owned it, it had appreciated dramatically in value because of its location being on one of the best lakes in the world. And Judge Earl decided that he was going to take that property and distribute the money that property represented to his buddy lawyers, the potential campaign contributors in the state of Nevada. So that became the agenda of the court. Well, when he dictated that this losing defense attorney be in charge of a sale, I went, that ain't going to happen. So I went back to New Hampshire, and to protect the property by being grabbed by this despicable lawyer, I sold the property. And within 7 days, I had secured a payment for the property, $500,000 more than the losing defense attorney was even going to list the property for. So he had no chance of getting any good price for the property, and he didn't care about that anyways, because all he wanted was his money, and the hell with the Feeleys, they can get what's ever left over, if anything. So he was going to arrange for this sale, which is an utter despicable action by this Judge Earl, to even allow something like that with such a gigantic conflict of interest. This was the losing defense attorney. He's the non-prevailing party. What the hell is he doing selling a home? He's not the judgment creditor. I am. The plaintiff is a judgment creditor, not the defendant. They lost the case. He represents a judgment debtor. And this judge is just out of it. He's totally bananas. Any rate, I secured the money for the house, and I went to my banker, and I told him I want cash. And he said, "Why do you want to walk around with that much cash? You don't want that much cash. Why don't you just take a cashier's check? It's the same thing as cash. It's cash equivalent." And, nobody can do anything about it. You've got the check, so it's not subject to court orders or anything else. And, you know, so anyways, I guess that made sense to me because what happens if the cash got stolen? I'd be out of luck. So I went, okay. So I accepted the cashier's check signed by that bank manager. So I put that in a safe place and went on. Well, the lawyers back here in Nevada and this Judge Earl, found out that I had grabbed the money for the sale of this home that the judge had no subject matter jurisdiction to order the sale of anyways. But being Judge Earl, he's the God. He made a statement in court. Any ruling I make as to jurisdiction in this court is a rule of law. This guy was nuts. Okay? I'll say it. Someone want to argue with me? 702-493-5222. Why don't you call Judge Earl, Alan Earl, see what kind of balls you got today? Give me a call. I'd love to talk to you. At any rate, I protected the money. I had a cashier's check. They were all going nuts. And now the show really began. Now the losing defense attorney looked like he wasn't going to get paid, so he orders up an emergency hearing in front of Judge Earl, and they start these court hearings. And this was a circus to beat all circuses. These were just going back and forth trying to figure out how really to get around laws and seize this money somehow that a bank had issued to me in the form of a cashier's check. They wanted to get this bank to start payment on that cashier's check. And remember, these are lawyers now and even a judge, and these people don't know what law is. They know how to get around the law, shall we say. So they're trying this and they're trying that. Well, none of it seems to be working. First thing they did is a temporary restraining order. Well, they served that on the bank, but I had already gotten the money from the bank. So that didn't work. And then they decided, well, they'll sue the bank to stop payment on the cashier's check. Well, who's going to be the plaintiff? Well, they dig up Wanda, my sister, the removed trustee for cause, who no longer has any standing as a trustee, and they can't use her name to sue the bank, but they had no one else, so that's what they did. The defensive lawyer back here in Nevada hired another lawyer in New Hampshire to help assist in this matter, and who they hired just happened to be working for the firm, the same firm that had created my mother's trust to protect the beneficiaries. Well, now this is a gigantic capital conflict of interest. I mean, what's going on here? But that's what these lawyers do. They don't care about the law. They just subvert the law, and they don't care because they're lawyers and they have a judge behind them in their corner, and they're going to get away with whatever they do. So this lawyer back in New Hampshire signs up to participate because they're promising to pay him. So anyways, he goes and he starts negotiating with this bank and inducing the bank to stop payment on this cashier's check. Well, the first thing, or one of the first things that happens, is the bank tells them we can't stop payment on a cashier's check. So they try all this stuff. They try these orders, the court orders, and this and that. Well, none of that worked. So now it goes down to where they're just running out of rope, and they've had I don't know how many meetings, but this back and forth with the bank had gone on for at least 3 months, and they finally convinced somebody at the bank, because the bank knew who had the check. They knew me. They know I had the check. They'd even sent me correspondence regarding that I had the check. So anyways, everybody knows, the judge knows here in Nevada, everybody knows that I have this check. I'm the trustee of the New Hampshire Trust, and I'm saving this to buy another home when the time's right. And that's it. So the home back there was completely protected in the form of this cashier's check being held by the legal trustee of the New Hampshire Trust. Now, Judge Earl and his games back here, he tried to arrest me and throw me in jail, finding me in contempt of court because I wouldn't turn this check over to him. So he swore out an arrest warrant for me. He's going to throw me in jail until I turn the check over to him. Well, there's laws about that too, Judge, but this judge didn't care about that. Any trustee of a trust is under an obligation, a binding obligation, that he has to protect the beneficiary's interest and the assets of the trust. And no court has any, and this is a spendthrift trust, by the way, no court in the land has authority to make any dictation whatsoever against a corpus of a spendthrift trust. The theory being that nobody owns anything. This money is being held for beneficiaries for their sole benefit. And until the beneficiaries actually receive payment of money, nothing can be attached to it. So this judge, again, completely oblivious, I guess, to trust law or whatever, he goes down this path and they try all this stuff, and then they get this lawyer back there in New Hampshire to actually file a case against the bank with my sister as plaintiff. Now, the problem with that is that they don't have any standing to do this. This bank that gave me the cashier's check, I find out, is so incompetent and a bunch of fools that they don't raise the issue that lawsuit, whatever it is, doesn't have any standing. Should have got it dismissed right away. But they are a bunch of fools. I had one of these supposed lawyers working for the bank tell me one day in an email, so I have it in writing, that don't bother us anymore because we consider this matter closed. So go away. So here's a lawyer, supposedly, this is a lawyer telling me to go away because they consider the matter closed. Well, let me tell you, you idiot, if you really are a lawyer, which I highly doubt, you may have graduated from a college of law, but I guarantee you've never taken a bar and passed it anywhere because you're this stupid. Anyways, the matter is not over. So, long story short, they somehow induce a bank officer to accept or enter an agreement. Usually a bank is required before they even consider a check having been lost, a cashier's check, that the person representing that they lost the check has to have a couple of things going for him. He has to be the remitter of the check. In other words, the person that bought the check's the only person who can say the check's lost. Or he can claim that he gave it to somebody else, and then that party can claim the check's lost. But it has to have been somebody in the chain of possession of that check is the only person that can possibly sign an affidavit saying the check's lost. He would have had to have it before he could determine that. Anyways, in this particular case, I've always had the check. No one else has ever had it. And the bank manager signed the check and handed it to me. The bank knows this. Everybody knows this. So that goes out the window. The other thing the bank's required to do is in the affidavit, the first paragraph states that the check was in my possession when I lost it. Well, the Nevada losing defense attorney signed an affidavit stating that the check was in his possession when he lost it. That's a friggin' lie. That's fraud. And the banker that accepted this affidavit knew it was fraud because they know I have the check. So what we have now is we have a bank in Connecticut is their headquarters. Officers of the banker in Connecticut. They're entering an agreement stating that even though they kind of know the check's not lost, they're going to accept this affidavit that the check's lost because the Nevada judge approved this agreement stating that the check's lost. Judge Earl signed a order dictating that the losing defense attorney enter this agreement with the bank. Now, they don't call this agreement an indemnity agreement like they're supposed to call it, the bank, before they issue another check. They have to have an indemnity agreement that holds the bank harmless. Should a check appear, then end up it's not lost. So that would put the bank in a bad position where they had to pay the check twice. So anyways, they're supposed to have an indemnity agreement. Well, they didn't call this agreement an indemnity agreement. They called it a stipulation agreement. So here's lawyers playing around with words, trying to Mickey Mouse this thing through somehow. So anyways, this agreement the bank officer signed, the only other signature on this particular document was a losing defense attorney, who Judge Earl had appointed receiver. Receiver to what? Who's he receiving what from who for what? another completely maneuvered, illegal motion by the Judge Earl, who had no jurisdiction to appoint a receiver to another state. I mean, it's just ridiculous. What this guy did is a joke. At any rate, he did it. Reutemann signed this agreement with the bank, this stipulation agreement, and this is a piece of work. I'll tell you what, a kindergarten student could have done a better job writing this thing. In this agreement, they actually indemnify Reutemann, the court-appointed trustee, which is a friend of the judge. He needed a trustee, so he removed me without cause and appointed a friend of his who would do what he said. Judge needed that so he could, get disbursements made and whatever out of this money they were stealing. So this guy, his name's Thorman, Randall Thorman. He negotiates with the bank. He was involved with his name all over the negotiations with the bank. Here's a guy that's supposedly a trustee for the New Hampshire Trust, and he's negotiating with the bank to get them to stop payment on a check so that the money can be given to a bunch of lawyers. That's against the law. And as a trustee, he has an obligation to protect the assets of the trust, like I'm doing, holding on to the check. So this is a completely illegal trustee. So at any rate, the bank, the Thorman, this illegal trustee, the receiver, this losing defense attorney, and the judge, Earl, everybody, they enter this ridiculous agreement. In this agreement, it indemnifies Reutemann, Thorman, all the other lawyers, everybody, indemnifies everybody. But I have the honor that it mentions me, Clark Feeley. It says if you want to go after anybody, go after him. So they're putting me as the responsible party for this agreement that I have nothing to do with. This is comical. It really is comical. It's a joke, but it shows clearly the depth that the Nevada judiciary has stooped to. This is an invalid, illegal court that should be responsible for all the damages and everything that they've caused here. And they will be responsible. And perhaps the taxpayers of the state of Nevada are going to have to write a check and make this all good, because a Nevada district court judge did all this. And he doesn't have immunity because he broke the law. He signed an order dictating that the losing defense attorney sign an agreement to enter with this bank, stating that a cashier's check is lost. And the cashier's check's not lost because he knows very well that I have the check. As a matter of fact, on one hand, he's signing orders of contempt of court because I won't give him the check. On the other hand, he's signing these orders to enter an agreement stating to the bank that the check's lost. This is absurd. It's ridiculous. This is the type of judiciary you have in the state of Nevada? It's ridiculous. But anyways, that's what we got. So now, long story short, the bank actually sends another check, I guess, to the state of Nevada, to Howard Reutemann, the receiver, who gives the money to this Randall Thorman, an invalid trustee. And the minute they get the money, the judge orders that it get dispersed immediately, according to his order. And he immediately disperses some $500,000 by order, and make sure that it's all given out within a week or so, because the judge knows that I'm going to appeal whatever order he finally files on this particular case. So he knows that I'm ready to appeal this at the drop of a hat. As soon as he files an order with a district court, I'm going to appeal it. So he has to get all this money given to all these lawyers before I get a chance to appeal it. Another totally illegal maneuver by this judge, who is not operating by any court procedures whatsoever, and he's violating laws again. And this is unbelievable. It really is. It shows the depth of what an invalid court looks like, and what a despicable criminal court is. Anyway, he does eventually, they disperse the money, and he files an order dated January 7, 2014. This case began on August 5th, 2009. Now here we are some 5 years later, and I finally get to appeal this mess that this judge caused, because he filed the order on January 7th, 2014. I filed an appeal January 21st, 2014. And my appeal issue was, guess what? That the district court did not have subject matter jurisdiction. And to this day, the court does not have subject matter jurisdiction. But the court system is set up such that you have to wait and wait and wait for the Court of Appeals to come in and confirm the fact that, oh, indeed, they didn't have subject matter jurisdiction. The problem with that is, and the reason I don't even think I had to do that, was the United States Supreme Court has ruled in a trust case, by the way, that the state of Florida did not have subject matter jurisdiction over a Delaware trust with assets, stock certificates being held at a bank in Delaware over a lady that died in Florida. The Florida wanted those assets, some $400,000, to probate because in Florida, like most states, they get a piece of the action through the probate court, so the probate court wanted that money. So they dictated that that money, those stock certificates, be sent to the court in Florida. Well, the trustee in Delaware said, no, sorry, you don't have subject matter jurisdiction. Well, the court actually went to the Supreme Court, and the Supreme Court decided by asking the following question: where are these stock certificates? Oh, well, they're in Delaware. Oops, well, this is Florida dictating that those shares be sent to Florida. They don't have any subject matter jurisdiction. Case closed. So they decided the case right then and there. Now, to the confusement of everybody, they went on to answer a personal jurisdiction issue that had been raised also, whether the Florida court had personal jurisdiction over this trustee in Delaware. Well, they concluded they did not have that either, but they'd already ruled on the case over subject matter jurisdiction, and it wouldn't have mattered how they ruled on the personal jurisdiction because it didn't matter. But they did say further into the ruling that the Florida court would not have subject matter jurisdiction even over people that they had jurisdiction over. Because some of the beneficiaries lived in Florida and the court did have jurisdiction over them, but even so, it didn't matter because the court did not have subject matter jurisdiction over the stocks. So the case was that was it. And then that's the way it is. It has been for years and years. There's another case that was referred to. Pennoa versus Neff has been established since 1878, and there's other cases, Gooby and Rose versus Himley and Livingston versus Jefferson, that go back to the early 1800s, that establishes a doctrine now in the United States called local action doctrine, that if any case is going to be heard over real property, the case has to be heard in the state where the real property is located, because any other state would be completely without jurisdiction to hear the case. There was a case decided like that in California recently in the Ninth Circuit in 2014, that there was a case filed between DirecTV and a person called Elderly Properties Limited or whatever. And there, this Ninth Circuit got this case. It was filed in California. And the first question was, where are these assets? Well, the assets are property located in Connecticut. Whoops. Well, there's no case here in California because local action doctrine dictates that the only place you could hear a case like this is in Connecticut. So if it's going to be heard anywhere, it has to be heard there, and it dismissed the case in California. So this is the law of the land, folks. This is what it is. And this judge in Nevada had completely lacked jurisdiction. And then the interesting thing about this particular case is the appellate court comes down with a decision on my case, because I appealed it, remember? I appealed to the Supreme Court. Well, the appellate court went in business January of 15, so they lowered my appeal to them. So the appellate court, being brand new, and I guess they have a propensity to go through great lengths to try to uphold all lower court decisions and to protect their judges. Judges in the process, like this Judge Earl, who broke laws all over the place, they had to protect them. So they come out with a ruling, they call it affirming the judge's prior rulings, but they made a fatal mistake in that they confirmed that there actually was a breach of duty when my sister, when the judge dictated that $26,753 be returned to the money trust that my sister had taken, and they confirmed that that was a breach of duty. Oops, now the New Hampshire law comes into play. There's a statute that demands that whenever there's a breach, the trustee that breached has to restore the trust to the exact place that it was before the breach. That means that my sister is responsible for 100% of all the fees, expenses, and whatnot that have been incurred because of her breach. Well, the appellate court accidentally, I guess, because they tried hard not to, but they actually confirmed that I've been right all along and that this breach occurred and that my sister's responsible for all the fees. So that's where we are. And then that was dated January 20th of this year. On April 22nd of this year, the Supreme Court weighs in another case whereby Judge Herndon in the district court here made a ruling over Nevada litigation that property in California be deeded over to these litigants in Nevada. So he was dictating real property's outcome in California. Well, that's the same thing. The judge doesn't have jurisdiction to do that. So the Supreme Court put a statement in this ruling stating that any court completely lacks jurisdiction to affect title to property located in another state. That's exactly my case, exactly. So the Supreme Court has weighed in on exact same facts that have been around for hundreds of years. So there's no secret here. This is a case that the district court here in Nevada had no jurisdiction. They've done some wild things that clearly shows their agenda, and they're getting caught. And they are caught, and they're up against a wall, and it's just a matter of time. My contention now is before Judge Gephardt, who I have made a motion to get $60,000 that's being held here in this state in the money trust name is my money. I was awarded that in a judgment done by Earl, and I want that money, period. They're trying to offset my award for my money to legal fees that are Wanda's legal fees, not mine. So here again, the court's completely criminal. They're just criminal. And Judge Gephardt's trying to do this, and he can't do it. So I'm saying do it. Do whatever you want to do, Judge, because of the prior rulings in this case, you're out of line. So you make your ruling, put it down there that you're going to try to steal my money, and I'm going to appeal it to the Supreme Court, and then finally I'll get the right rulings that I've been waiting for since 2009. They have to rule that way. They already have. So it's just a matter of crossing the T, dotting an I, that the case that they just ruled on April 22nd has the exact same situation as here. The property wasn't in Nevada. So that's it, guys. You're done. You're finished. So good luck to you. Anyways, it's been a real ball. It's been a torture of my life for going on 7 years, but we'll get it. We got it. It's just a matter now of watching the circus play out and watch Gephardt go absolutely crazy, and he deserves it because he doesn't qualify to be a judge in my case, and he's proven it every day over this particular matter, and I'll make sure that he pays the price on this because he's doing illegal things, and it's going to come out. At the end of the day, everybody will know what this judge did, and he's doing illegal things trying to cover up for Judge Earl, who did illegal things. So this court is completely out of whack. Anyways, enjoy your weekend. I'll enjoy mine, and we'll see what happens on this case as it comes to a grinding halt sooner or later. And enjoyed it. So you all have a nice weekend, and I'll see you back here on the flip side come Monday.